Welcome, everyone. And I didn't get, we'll get to that at the end. If you brought a friend, just remind me. We'll do the drawing for the gift card, okay? So my name's Karena Stipp. I am a senior specialist realtor, and this is just the tail end of 3 years that we've been doing seminars now here. Can you imagine? 3 years we've been doing this. And so today we're going to talk about the Ladybird deed, or the enhanced life estate deed. And let me grab my clicker. Today, our special guest speaker is Michael Paul with Michael Paul Law in Rollsville. And he's a great guy, I'll just tell you that. We've worked together on nonprofit fundraising, and I've been in and out of his office quite a bit, and he'll never do you wrong. So all of his accolades are here on the screen. I'm going to let him tell you a little bit about himself, and then I'm going to switch over to his presentation, and then we'll wrap up at the end after he's finished talking with some final slides. So let me hand over the microphone.
Good morning, everybody. Good morning, everybody. Hopefully everyone can hear me. All right, good. So, yes, Michael Paul. I'm an estate planning attorney in Rollsville. We also do probate, so we're familiar with both sides of that aspect of our lives. We're going to talk about the enhanced life estate deed today. I've been practicing for about 30 years, been in Raleigh area for 20, in Rollsville for 10. Opened my office a little over 5 years ago, and my wife and I run it with Gigi, who's also in my office. And very blessed to be able to take care of a lot of people, and I hope you find the information today worthwhile. And we're going to make it interactive, so if you have questions, feel free to ask them as we go through this. It may be new to some of you may know it, but I think it can benefit all of us as we mature in life. So with that, let's get started. So I don't like to assume anything, so how many of you own your home? How many of you have a will? How many of you don't have anything? All right. If, and some of you are probably married, but if you're the surviving spouse, and if you passed away tomorrow and you have a will, how long do you think it would take for your heirs to receive your home? Anybody? Yeah, it's a while, because in North Carolina, you have to go through probate, and it can take, the courts give us a year, it sometimes can take longer. So the enhanced life estate deed can change that, as we'll discuss. All right, so what's an enhanced life estate deed? It's a deed. You're actually deeding your property to the heirs that you select. And the beauty of it is, some of you may be familiar with the life estate deed. This is different. You own the house. It doesn't transfer. No one has an interest in the house until you've passed away. And if you're a husband and wife, not until both of you have passed away. So it's pretty cool in that sense, because you own it, you can refinance it, you can sell it, you can move out of it and rent it, you can do whatever you want with it. It doesn't go anywhere until the last owner of the house passes away. And then it transfers automatically. It avoids probate. It's outside of the probate process. So it saves all that time. It's an immediate transfer upon the passing of the last owner of the house. And why is that important? As we just talked about, it can take a year or more sometimes to transfer the home to your heirs. And, that's a lot of time. And it's a lot of expense, because if you go through the probate process, if any of you have done it for someone else, it's a lot of work. There are a lot of deadlines. There are court costs. If you hire an attorney, attorneys aren't cheap, so there's a lot of costs that go along with that. It makes life easier. If you have a will and you own a home, you can augment your will with the enhanced life estate deed. And that will take that out of the probate process. And then there are other things that can be done, which we may or may not talk about this morning, but certainly you can get the house out of the probate process. Yes, ma'am?
What if your house is in a trust?
Trust is a separate matter, and a trust is a wonderful tool as well. So if your house is in the trust, you will avoid probate. And many people are doing trusts, but there are still plenty of people that only have wills, and this is really intended to protect them. Yeah, but I will, yes, one second. There is a benefit to, when you have a trust, to use an enhanced life estate deed in conjunction with the trust, and we'll get into that. And it's avoiding Medicaid costs, Medicaid reimbursement. I'll get into that in a little bit, because we do a lot of trusts with the enhanced life estate deed to the trust when the owners pass away. So, yes, ma'am.
I thought, I was told, my will says that everything goes to my children. So this isn't true with your house?
It is, but a will doesn't avoid probate, it guarantees probate. So all a will does is says that here's where I want my stuff to go. Let me back up one second. If we own assets in our own name, when we pass, nobody can do anything with them. So your powers of attorney die with you. So no one has the authority to act on it. So if you own your house by yourself, and I'm making this up, and you pass and your will says it goes to your children can't just take the house. They have to apply to the clerk of court, say it's Wake County. They go to Wake County Clerk of Court, apply for being the executor of your estate. They will attach a death certificate, they will attach the original will. The clerk of court, 4 to 6 weeks later, will issue what's called letters testamentary. Letters testamentary give your children the authority to marshal your assets. Okay, so whoever you select as your executor, your personal representative in your will, has to go through this process to get letters testamentary. Once they get letters testamentary, there's a number of things they have to do, but that letters testamentary is like a power of attorney for when we've passed away. Until they get that, they can't do anything with your assets. So if you have a bank account in your own name, if you have a house in your own name, a car in your own name, and you pass, they can't do anything with any of those. Yes, sir.
If I specify in my will that one of my children has power of attorney, that doesn't bypass that? They still have to...
Powers of attorney die when we die.
But it doesn't say that in the will. It says it survives.
It doesn't matter. They die, by operational law, when I pass, my powers of attorney die with me. The will cannot supersede that.
Even though it says...
It doesn't matter. No, sir.
What's the point of the will then?
Well, the will shows how you want your assets distributed when you pass away. But there's a process to get to that point, and that's what we're talking about. So, yeah.
That's not the way it was represented to us.
I'm sorry to hear that. And that's why, as an aside, 10 years ago, about 5% of my practice was wills, or was trusts. Today it's over 95%. Because a trust will avoid probate for all your assets that are in the trust. That's a separate issue from today, which we may get into, but a will by itself will not avoid probate. So if you have a will and you want to at least avoid probate with your house, this is a way to do it.
I guess a whole other question then, you get into, is one attorney says it does avoid it, and the other one says it doesn't. And who do I buy into?
That's a tough situation, and I do these every day. My practice is estate planning. This is what I do, and I'm on elder law associations, and we all talk about these, and this is an invaluable tool for people, especially if you have a will. And they're still a very valuable tool to work in conjunction with the trust.
It just seems odd to me that I could have made a list of who gets what, and not drafted a will or get an attorney or paid the $500 or whatever, and I would have been in the same boat. Because I thought by designating powers of attorney and all that other kind of stuff that I was doing something.
And I'm sorry you were misled on that one, but yeah, powers of attorney die when we die. And the only way to provide someone authority if you have a will, is by going to court. And the court will actually give authority to your personal representative to do the things that you want them to do in accordance with your will.
See, I was told the same thing, that's why I was asking.
Yeah.
I was told the same thing, I thought I had everything taken care of.
Right.
Yes, how about the medical power of attorney?
Same thing.
That dies with me,
Yes, sir.
so if I designate where I want my remains.
That part will continue, but that's the only thing that you can do with it. Yep. And that's the only thing that would make sense with a medical power of attorney, because once we pass, we don't need it anyway, other than disposal remains, organ donation, things like that.
But there are attorneys out there telling you trusts are no good, no, they're lying. They don't like them. They say,
Well, they may not like them. They may not like them, and there's plenty of attorneys that don't do them. They're more complicated than a will.
okay.
But, yes, ma'am.
What then if you have the house listed, the beneficiary, who named a beneficiary of your property?
Please explain what, so
Maybe I'm using the wrong word.
possibly.
Is it paid on death or a transfer on death? Some states have that. I don't know if North Carolina
North Carolina does not.
Okay.
This is our version of a transfer on death
Oh,
deed.
it is, okay.
It is.
Because
So there's
my
about-
mom lived in a state that was transfer on
Sure.
death.
Florida
Yeah.
has them. New Mexico, I think, has a transfer on death
Yeah,
deed.
Missouri.
There's 9
My
states
mom was in
that
Missouri,
have different
yeah.
things. But
Yeah.
so you could possibly have your child or children listed on the property as joint with right of survivorship, and it will transfer to them. It doesn't avoid probate, but it'll transfer to them. So if they wanted to sell it within 2 years of your passing, they would have to open a full probate estate. Yes, ma'am.
If they're joint owners, though, they don't inherit the cost basis, is that correct?
No, it will step up the basis.
Oh, it will.
Yes. There's an irrevocable trust, which will not, but a revocable trust or joint with right of survivorship will step up the basis when we pass to the date of death value. All right. So these are some of the benefits of the enhanced life estate deed. So even though, and I'll make it up, I've got a house, I've got 2 kids, I don't only have one, and I put them on the deed, I still own the house. I can do whatever I want with it. I could sell it the next day, I could refinance it, I could rent it out, I could move out and rent it out, I could do whatever I want with it. I can go ahead and redeed it and change who's getting it when I pass away. I can do whatever I want with it because it's my house. If I don't do anything with it, when I pass, it will transfer automatically to the grantees, my heirs. They will avoid probate. They could go and sell it the next day if they wanted to and avoid probate. Whereas otherwise, if you just leave it in a will and it goes to your children, once they get it, if they go through probate, then they'd be able to sell it. If they don't go through probate and just update the deed, if they sold it within 2 years of your passing, they would still have to open a full probate estate. So the enhanced life estate deed avoids all of that. Yeah, and the process is straightforward. I'm not going to say it's simple because it has to be very specific, but you're creating a deed. You're deeding it to your beneficiaries. And we're preparing the deed, we're recording the deed, and the day it's recorded, it's in place. And there's some Medicaid protections in there as well that we'll talk about in a few minutes, but that's very important, is that the day it's recorded is the day it's there, and it provides all of the rights and responsibilities that go with it. Yes, sir?
What if the beneficiary dies before you do?
Then you would have to update the deed again.
Or can you have,
So if you have 2 children, you could have both of them on there. You could have them as tenants in common, where each, say you have 2 children, and you put both children on there as tenants in common. That means they have a right to it if they pass before you. When you pass and it transfers, half of it would go to the surviving child, the other half would go to the estate of the other child. But odds are, if that would happen, you'd probably update the deed.
it's not like money where it goes to their children and like your grandchildren or something.
Not automatically.
Buy it in what do they call it, stirpies or,
Per stirpies, Yeah.
Can't do that?
Not on a deed, not like that, no, sir. No. So as we alluded to a minute or two ago, we're one of 9 states that has this type of deed. And there's different names to them, but they all act pretty much the same. And it's basically, it's your house, you've transferred a future contingent interest in the house subject to whatever you do during your lifetime. If you create the deed and you live and 30 years later, you pass away, it will go to your children automatically. They will avoid probate. They could do whatever they want with it. So there's not a state statute. It is common law, but it has been tried and tested in courts. They work. And like I said, I'm in several elder law groups. We all talk about them, and we all use them. I do enhanced life estate deeds virtually every single day of my practice. And anyone I talk to who's 50 years or older, I will at least mention it to them for several reasons. One we'll get to, but this is the main one, is that it protects the asset. Yeah, yes, you could get a trust, and a trust will do the same thing, but there's still a potential value of doing an enhanced life estate deed with a trust, and certainly with the will. Most of us, our house is our biggest asset. It's a way to protect it and avoid probate. Makes it easier for our heirs, who are typically our children. So. We mentioned a little bit of life estate deed. This is very different than a life estate deed. So if you've ever heard of someone, I transfer my house to so-and-so, I'm retaining for myself a life estate in the property. A life estate, traditional life estate, is the person who does that. They have the right to live in the house and use the house for as long as they live. Sometimes as long as they stay in the house. But they have it, and they can stay there. They can do whatever they want pretty much with it. And if we call the people that will take it after they pass, the remainder owners of it, they couldn't sell it without having the life estate holder sign off on it as well. So, it's a restriction on that as well. Whereas the enhanced life estate deed, if you're granting the property to your children, you retain full ownership, full rights to do whatever you want with the property. If you wanted to sell it a month after, a year after, whatever, you can sell it on your own. They don't have to sign off on it because they don't own it. They have a future contingent interest in the property. Yes, sir?
Does the Ladybird deed, if I take it out of the house and then I decide to sell it, does that complicate the sale?
Does not. There is no complication at all. You could sell it. You're signing it just like you would normally, and then you could buy another one and do a Ladybird deed on the new one. Just has to be your primary residence. So yeah, these are the benefits of the enhanced life estate deed. Potential Medicaid planning advantages. So this is one of the reasons why I mention this to all of my clients who are 50 or older. If you have an enhanced life estate deed, and if at some point in the future you go into an assisted living facility or nursing home, and if Medicaid ever paid for it, with the normal deed, when you pass, Medicaid would put a lien on the house would be sold, they would get reimbursed, and the net proceeds would be distributed in accordance with your will. With an enhanced life estate deed, they can't touch the house. So Medicaid won't get reimbursed. The house will pass to your heirs. Did I do something wrong? I pushed the wrong button, yeah. Let me get back there. Wrong one, there it is. And the other thing is, and what Medicaid looks at is transfers of assets for less than fair market value. And they have a 5-year look-back period on that. So if you gave your child $100,000 and then you went into a nursing home, Medicaid paid for it, they would claw that back. With the enhanced life estate deed, it's protected the day you record it. There's no look-back. So if you did this deed, I'm working on one right now where we've got someone who's soon to be going into a nursing home, and we're doing this now to protect the house. Like I said, the day it's recorded, the day it's protected. If you went in a month later, Medicaid couldn't touch it.
But what happens is say that person does what you said, goes into the nursing home the next day. Does that
No, can't be sold while you're alive because it can't.
It could become a rental or it could
Yes,
be
ma'am.
vacant.
A child could move into it. Yep, they could do in-house care, which is often the times, but if it's sold, the protection is lost while the owner is alive. But if it's not sold, it's protected asset from Medicaid. So yes,
So the way you described this to me, this is how I understand it,
Sure.
was that if I did this and then I go into the nursing home, I go into the nursing home saying, but I may move back to the house. And that's
Absolutely.
the loophole, right?
Yep.
Okay, that's how I understood it
Yeah,
from you.
and that's the truth. If you go into a facility, I intend to return to my home. That's the only statement you have
which
to
may
make.
not
Which
really be feasible.
never.
But you say
never,
it.
but yes,
And then that's the loophole that's in this law.
and it protects the house. Yeah.
And that's why there's not the 5-year look back.
That's
And-
that's part of it. Yeah, the protection's there, but it's the deed protects the house, and there's no 5-year look back because of the nature of
The way
the
it's
deed.
written.
Correct.
Okay.
Because there's no transfer of interest until we pass. Yes, sir.
Expand on that.
Sure.
What if the surviving spouse, you have one of these things,
Mm-hmm.
surviving spouse contracts dementia,
Mm-hmm.
and they're no longer responsible for their own actions, and you can't act on their behalf? Do they still own the house, or can the beneficiary take over as the durable power of attorney and dispose of the house?
Two different things. So the beneficiary has no rights to the house. The power of attorney, depending on how the power of attorney is written, may have the authority to do something. If the power of attorney, the agent under the power of attorney, sold the house, the liquid assets would not be protected. So it would be not in their best interest typically to sell the house while the owner is alive. So in your scenario, the surviving spouse may go into a nursing home, the power of attorney is taking care of them, then maybe they rent the house out, and the proceeds, net proceeds from that may go to contribute towards the payment of the nursing home or whatever, but when the owner passes, the house transfers to the beneficiaries.
So if the owner's alive,
Mm-hmm.
but not able to make their own decisions, they're legally declared incompetent,
Right.
but they're alive,
Mm-hmm.
you can't dispose of the house, it doesn't transfer.
You can, if the agent under the power of attorney has the authority to sell it, they could, but once it's sold, the proceeds will be subject to Medicaid.
Subject to Medicaid,
Yes.
how about probate?
Well, they're alive, so if whatever's left over would be part of the probate assets in the probate estate, yes. Yep. So the whole beauty of Medicaid avoidance is to retain the house until the owners pass away. So you're right. Couple, one goes into a nursing home, we've got an enhanced life estate deed, they're protected. The other spouse can live there, and when both of them pass away, it will transfer to the children.
I guess what I'm thinking though is that if there's only one spouse remaining
Mhm.
and they contract dementia
Mm-hmm.
and no longer responsible, but they have to go into a memory care unit that costs $15,000 a month,
Mm-hmm.
and they'd really like to have the proceeds from their house to pay for that. There doesn't seem to be a straightforward way to get that.
Oh, there is. I would rather Medicaid pay for it and me keep the $15,000 a month so that my children can get my house when I pass.
No, Medicaid won't pay for it if I have $500,000 in the bank.
Well, that's a separate issue. If you sell the house and have $500,000 in the bank, you're right. If you have the house and $500,000 in the bank, the $500,000 is going to be depleted unless you do some other things, which are a little out of the scope of what we're talking about today. But there are other ways to protect at least some of those assets. Right. But yeah, this is a way to protect the house, for avoiding probate and avoiding Medicare reimbursement, Medicaid.
It just sounds to me like this life plan thing doesn't protect the house if you become demented. And you're alive, but you're not functioning, you can't deal with it, and you don't get the money from the house. You can rent it, let other people live there, do whatever, and that's the only source of income you have from the house.
Well, if you're in a nursing home, you're only allowed about $70 a month anyway. So
What do you mean it's allowed, so?
over and above, yeah, that's right.
You just get if you're on
A stipend.
Medicaid, you only get like
If I'm on Medicaid,
yeah, if you're on Medicaid, which in this case
The house.
Yeah. And have Medicaid pay for it rather than your estate.
Correct.
Yeah.
Yeah, the whole point is to try and not deplete your estate. And right now, specifically, not deplete the value of the home so that it will pass to your children when you pass away.
I have a question.
Sure.
So let's take Tom's scenario. So Tom goes into skilled nursing. They have a life estate deed. Gail develops dementia and needs to go into memory care. So now they're both in two different
Sure.
communities, right? But in this case, couldn't they use the loophole in both cases and say, but I might
Absolutely.
go back?
Yeah,
And then that
Medicaid,
still protects the house, and Medicaid pays for them both.
if Medicaid pays for them
each
both,
in a different
then
facility.
when they both pass, the house will transfer to your children.
Okay.
Well, that's true.
True, but in
That's
some
true.
cases, and
That's all
if,
there
if,
is.
if this is your asset, if your house is your asset, which is the case for a lot of people, that's their
Right.
largest
In that case, if it's my only asset.
yeah, yeah,
But if I have other money, which will disappear really quickly once I get into
it will,
memory care, then I can't go out and sell the house.
yeah.
Well, then the house would still be protected. When you depleted that, Medicaid would kick in, the house would still be protected.
But I
So-
gotta wait and then move fast. Sell the house,
In that
You're
case,
not
it
selling
would
the
be
house at all.
$70 a month.
In that case, if you depleted all your other money and still were in, which I doubt, honestly, that would be the case because the average person only is in skilled nursing for 2.5 months at end of life. That's the statistic
Is that
nationwide.
really that
Yeah,
low?
it's only 2.5 months. Memory care is a different thing. Yeah, memory care can often be, if you're required to be in there because you're a wanderer, and you have to be in a locked, it's pretty close, yeah.
Right. Oh, yeah.
Yeah, it's around here, you're going to be around $10,000, $11,000 a month for memory care per month. Skilled nursing on average nationwide is $15,000 a month. Yeah, but that's the
No matter how
highest
much you
level
have
of
in the
care.
bank, it'll go quickly.
It will go quickly. But in that case, if you depleted all of your liquid funds or all of your investments, you would still have money to leave to your kids if the house,
house.
sat there during that time.
Correct.
Yeah. Well,
But you
would
wouldn't
have,
need it.
Yeah.
If Medicaid kicked in, you're covered, so
Right.
you wouldn't need it.
Right.
It depends on the facility.
Sure. Sure.
Go ahead, I'm sorry.
Oh, you're good. No, it's important. So yes, as we've talked about, typically if you transfer an asset at less than fair market value, there's a 5-year look back. Medicaid will try to claw it back. With this, it's protected the day you record the deed. And so if I give give a charity $500,000, and then 2 years later I go into a facility and I want Medicaid to pay for it, they won't because I've got a penalty because I gave away $500,000 within 5 years of me going into a facility. So there's a penalty that I will have to continue paying for it until the penalty is met. And there's a formula for it, but it'll be several years that I would have to pay for the nursing home or whatever facility before Medicaid would kick in. So, like I said, the house is protected the day it's recorded, so there's no look back. The other part is when we pass, say I bought the house for $100,000, I have a enhanced life estate deed to my son, I pass, the house is worth $500,000, he gets the house at a $500,000 value. He sold it the next day for $500,000, he paid no capital gains tax on it. In North Carolina, there's no inheritance tax, and the federal inheritance tax kicks in at $15 million per an individual and $30 million for a couple. Yes, ma'am. Do you have a question? Okay. Yes, ma'am.
Would you repeat that last part? North Carolina has
No inheritance tax.
That's for real property.
Yeah.
Yeah, and so if you have investments,
Yeah. But it's still, it's 15 million. is
Yeah.
The floor for inheritance tax, and I think it's what, 45% or something like that?
yeah,
And then 30 million for a couple. Yeah, so there's no gift tax, property taxes shouldn't be affected at all. So, yes, ma'am.
kind of
you're doing it to avoid probate.
Yes, ma'am.
And so you do this, you're going to avoid probate on your house. You've got all of your accounts and investments in a payable upon death.
Yes, ma'am.
What if you own a Mercedes-Benz?
Depending on the value of the car, if it's less than $20,000, your heirs, your beneficiaries would do an affidavit for collection. It's a small estate, it's different than a full probate. But yeah, so if you had a Mercedes-Benz, at the minimum, as we get older, put one of our kids on a joint with right of survivorship. So it'll pass to them.
To avoid probate.
Yes. Yeah.
And if it's less than a $20,000 car, you don't even worry about it.
Well, yeah, because it's a very small estate. It's a 90. Basically, what you're doing, back to your point earlier, is you're opening a small estate to get authority from the court to be able to transfer title on the asset. Because we don't have authority when the owner passes, because the powers of attorney die when they die.
And the other option is to...
Well, another option is put it joint with right of survivorship with a child or other beneficiary, or put it in a trust, because a trust will avoid probate as well. So, like I said, the reason we're talking about this is because many people have wills, and many of us own homes, and this is a way to transfer the house and avoid probate with respect to the house. Because a will only, you will be subject to probate. There are times when it may not make sense. Say you have 5 children, and 1 or 2 of them may not be treated the same as the others. They could complicate matters, so if you leave it to all 5 of them, there could be a lot of infighting and problems with that. Another one is you have several children, one of them may live with you in the house, and when you pass, could be a huge fight as to what to do with the house because one of them thinks they need to continue living there. So, those are situations where it may warrant a closer look on whether this makes sense. And just, in order for it to work, it has to be done properly. So just make sure you have counsel who's familiar with these and does them, that understands how they work. Yes, sir.
Is there, to your knowledge, any ambiguity in North Carolina state law regarding these Ladybird things? Because when we saw this seminar being advertised, I did a little search on the internet to see what was going on with it.
Sure.
And what I found out pretty universally was that there's a lot of discussion about how it applies, how it can be constructed so that it applies properly, not just in North Carolina, but other states too.
Sure.
And they said, actually one of them said that if you've got 10 attorneys, half of them would say it works and the other half would say it doesn't work. I'm just wondering what your take is.
Well,
all these
it does work, and I use them. I've defended them from Medicaid as well as on a probate side. It is not subject to statutory law. It's common law. But it does exist. They have been tested in court successfully. So they do work. They are currently being used. Like I said, I'm in a group with several hundred other estate attorneys, elder law attorneys, and we all believe in them. We all use them. But I've had people call me, do you know what a Ladybird deed is? Do you know what an enhanced life estate deed is? And I said, yes, I use them every day. You're the 5th attorney I've called, and you're the first one that knows what it is. So not all attorneys, even ones that might profess to do elder law or estate planning, may know them or use them. So, but they are gaining in popularity because of the benefits of using them. Yes, ma'am.
I have 2 questions. So is the Ladybird deed and the enhanced life estate deed one and the
They're
same?
same thing.
One and the
Yes,
same?
they're synonyms. Yes, ma'am.
Okay. Second question, did I understand correctly if I set up a trust and say I only have 1 child, but that child predeceases me, I can't have a caveat in there for the nephew. I have to go back in and redo the trust. Is that correct?
No.
Oh.
No.
I can
A
have a
trust can be
caveat?
trust is a lot more versatile than a will.
So I can have it goes to
Absolutely. So-
one, but in the event of predecease.
You could do the enhanced life estate deed to the trust, and then the trust dictates who gets what. It goes to my son per stirpes. So if he predeceases me and has children, it would go to his children. Or you could say, if my son predeceases me, it goes to someone else. So yeah, we do those all the time, and they all work. Yeah, a lot more flexibility with the trust than a will, but this is a way to, like I said, protect the home, especially if you only have a will. Yes, sir.
What if I designate that my executor is going to be an attorney's office?
Mhm.
And I don't designate beneficiaries, have beneficiaries for real property, but what happens with the house if you have one of these things? How does it pass through probate under those circumstances? Any differently?
Well, I mean, you can have I'm executor for a number of wills and trusts, or successor trustee. So it really it depends on who you're leaving your assets to and how it's done. So like you could have millions of dollars in the bank in a number of different accounts, brokerage accounts, money market accounts, CDs, bank accounts, and you could have TOD or POD beneficiaries on them, payable on death or transfer on death. All of those liquid assets will transfer automatically outside of probate because you have designated beneficiaries on them. So it just depends on what you have structured for the house. If the house is in the will and it says goes to my children, they're going to be subject to probate.
But if I say, just sell the thing and put the money into the estate to benefit the estate,
It will go through probate.
unless I have one of these.
Correct.
But if I have one of these and an attorney is the executor, it'll just go into the estate as I designated via this.
You would not put it in the estate. You would have a beneficiary for it. Because if it goes into the estate, you defeated the benefit of the enhanced life estate deed.
I'm saying I have the enhanced life thing,
Mm-hmm.
and I designate that I want the attorney to sell the house if I die. Can that be done? Without, with bypass probate and all the proceeds go into the estate. Let's say I want to leave it all to the cancer center and do it. I want them to have all the money, including the house.
What you would do is do an enhanced life estate deed to the cancer center at Duke. They would be the grantee. Yes, sir.
So my question is probate longer without a will? Because I've had clients who've had letters of testamentary, and it really doesn't take very long. And I mean,
Right, it's months.
Typically. It's not a super long
Typically.
amount of time.
Well, what happens is you have to file for the application to get the letters testamentary. Wake County, it's 4 to 6 weeks to get that.
Yep.
Then you have to file a notice to creditors, which is that little ad in the paper, hey, John Doe passed away. If you've got a claim against his estate, you got 3 months to file it. So you have to wait until then before the assets get distributed. But if there's a house, once the notice to creditors ad is published, you can put the house up for sale.
Yeah, I've
So,
done
yes.
that. Yeah,
Right.
and that was pretty quick.
Yeah.
So we waited
Couple months.
a month or so,
Yeah.
4 or 5 weeks.
Yeah.
Letters of testamentary came in, put it on the market right away, and
After the
by the
notice to
time we
creditors is
closed,
published. You have to publish the notice to creditors.
right, that had happened, and so
Yeah.
then by the time we
right.
closed, that window had closed
Right.
for anyone to put any liens on the house.
Right.
And we were fine. Yeah.
Yep. Yeah, and we've gone through this, the whole way to avoid probate is to have the enhanced life estate deed, leave it to your children, if that's your call, and then once you pass, it will go to your children automatically. They won't have to go through probate with the house. So, common misconceptions that you lose control of the house. You do not. It's your house. No one can do anything with it but you until you passed away. And it's not for the wealthy anymore. It used to be the same misconception about trusts, that they were only for the wealthy. Many people do them now. Like I said, 10 years ago, 5% of my practice was trust. Now it's over 95%. And they're not all wealthy. And I mean, if it's done right, like I said, I do these every day. And I've had several counties, several Medicaid counties fight with me. I've won every one. We've saved our clients millions of dollars in protecting the homes from Medicaid trying to get reimbursement.
Explain that third one a little bit more.
Oh, if it's not drafted properly, it won't have the protections in it, and it won't serve its purpose.
So if it's not clear how to do that, in other words, let's say I had gone to a different attorney and he says, yeah, I know Ladybirds and he does it wrong, it's more harm than good.
It won't provide any good. It may not be any worse than a normal deed, but it won't protect the house from probate.
But it's, I vow to your knowledge how to do this correctly.
Mhm.
But you're saying that there's other attorneys out there that may not do it correctly.
It's entirely possible. Yep. Or they just don't know what they are.
It's not a straightforward procedure, I guess. It's a little bit of,
To me, it is because I've been doing them for years. So, but I can't speak about anyone else.
okay.
But yeah, like I said, it's a valuable tool if it's used properly. Yes, ma'am.
Can you provide an example of when it's not drafted? How would it not be drafted?
It just wouldn't have the same protections in it. So the enhanced life estate deed lists out your rights. It says that you can sell it, you can refinance it, you can rent it, you can do whatever you want. You can change who the grantee is. All of that's spelled out in the deed itself. So it's recorded that way, which affords you the protections that it's supposed to give you so that you can do anything you want with it because it's your house. And it stays your house until you pass away.
So if it wasn't done correctly, like maybe one of those things was left out.
Then you wouldn't have that protection. Right. Yes, ma'am.
So if you think that you have done everything correctly, if you think you've done everything correctly, like I was told, but it sounds like I've never heard of this before, you don't have to necessarily do your whole will or go into a trust with everything, or can you just add this?
Oftentimes you would. So you may have in your will that the house goes to so-and-so. If you did this, this would supersede what's in the will. So the rest of the will would still be intact, but the house would be taken care of via the enhanced life estate deed as opposed to the terms of the will.
So I wouldn't have to do a whole
Correct.
new everything?
That's right.
Okay, thank you.
If I come to you for one of these things, I don't want the house to go to anybody in particular, but I want it to be liquidated, and then the liquid assets be divided up amongst the beneficiaries. Can I accomplish that?
This won't get you anywhere because you're putting the assets, the liquid assets or net proceeds into your estate, and that would be subject to probate. Not for what you're talking about. That scenario would not work. No, sir. Yes, ma'am.
If I put I do one of these trusts, but before I did it, I had intended that my child was going to be the executor of the estate in my will. Can that child still be the executor, or does this child need to come back to you?
No. If you're saying that you're going to do an enhanced life, you have let's say you have a will.
Right.
Your son's the executor.
Right,
And he may be the sole beneficiary.
yeah,
And you say in there that the house goes to your son.
right,
And then you do this.
Yeah.
And we deed the house to your son via the enhanced life estate deed.
yeah.
This will be outside of probate, and he would still be the executor of your will for anything else that might be subject to probate.
So I don't necessarily have to designate an attorney as the executor?
No,
just
you do
because
not.
I have this?
No, no. You would not, no. Sure.
Let's say I have two children, okay, and my house is still unsold when I die, and I have one of these things, and I designate that one of my children is the beneficiary of the Ladybird thing.
Mhm.
They get the house, 100%, and then in my will, I designate that and they're also my executor, that one child.
Mhm.
And I designate then that they have to sell the house and split the money between the two beneficiaries, my two children. Will that work?
No. No, because the deed supersedes the will. So when you pass, if you have an enhanced life estate deed to child A gets the house.
Right.
And the will says it's split between the two. It can't be because child A owns the house.
Okay, child A owns the house, and my will says, once you own the house, for the Ladybird thing, it's got words in there. Now the will instructs you to sell it and split the money between the two kids.
There's
You
no,
have the house to yourself.
there's no legal obligation for that child A to split it
Even
or
if
sell
it's
it.
in the will.
No, because the house is not an asset of your estate at that point. So the will has no control over it.
But let's say I do the Ladybird, and I say the house goes to both kids. How do I designate what to do with it then?
Well, then they could decide whatever they want. One could buy the other out. They could both decide to rent it. They could both decide to sell it.
I can't designate, you must sell it and liquidate it.
You can put that in there as a moral obligation.
But not a legal one.
No, because it's not covered by the will.
Why is that important to make, I mean, because my brother and I inherited a house together and neither one of us wanted it, but if my brother had wanted it, he could have just bought me out.
But it's a scenario that avoids everybody fighting.
Yeah, okay. I can see where,
Sell the
Yeah.
house, I think it'd be worth more next year, let's wait. I don't want to wait, I want the money now. That kind of-
I see.
So you put
Yeah.
it in the will, you say, sell the house, and the proceeds split between your children.
Moral obligation,
No, if you put it, you wouldn't use this. You would just put, no, no,
but then it goes through probate.
correct. But that gets you where you want to be.
No, it doesn't.
Can
The
he
other-
just write the law? He would
The
like
other
to just
way-
write the law.
The other way would be to do a trust, and you could use a Ladybird deed for the trust, more for Medicaid's purposes, and then when you pass, it goes in the trust, and the trust dictates that it be sold and the proceeds split between your children. And that would avoid probate.
The trust makes it a legal obligation as opposed to.
Correct. That's right. Yes, sir.
They go back and strangle the others. The trust was a bad idea.
Well,
Well, you said trust, there's no advantage to a trust in North Carolina. Those are the words I heard.
and I'm sorry he told you, he or she told you that, but
Well, maybe it was 8 years ago, I don't know.
yeah, yeah. I used to work for an attorney, and she said wills are horrible, probate's the worst thing in the world, and she sold trusts, and she's sold them for way more than I ever will probably, but, you know, she used scare tactics, and it doesn't work. I'm agnostic. If you want a will, I'll do a will, and I'll talk to you about this. If you want a trust, I'll do a trust. It's your call based on your scenario, your situation, not mine, but I'll give you the best advice I can under the circumstances.
Did we have other questions on that? Okay.
We're there. We're there. Yes, sir.
I have a question about the trust, setting up a trust. I've seen places where people say you shouldn't put your motor vehicles into the trust. That what we were telling her to do was you put it in a trust. But there's people that are out there saying that you shouldn't put that in a trust, and I don't remember if there was a reason or not. I don't remember the reason why you shouldn't, so I've always not wanted to do that. But is there really?
If you pass and you have a trust, and you have a vehicle or several vehicles that are in your name only, the trust does absolutely no good for those vehicles. So the only way you will pass tangible assets without going through probate with the trust is to put them in any titled assets. Cars, trucks, trailers, motorhomes, motorcycles, RVs, whatever. Any titled asset that you're going to own when you pass should be in the trust. Otherwise, your heirs will have to go to court, open a probate estate, depending on the value of the vehicles, whether it's a small estate or a full probate estate, to transfer title. Because once you pass, when it's in your name, nobody has authority to deal with it. Putting it in the trust avoids that problem.
That means transferring the title.
Absolutely. Yes, ma'am.
DMV.
That's correct.
Fun stuff.
Yes, ma'am. Yep, it does. Yeah.
And is transfer on death available in North Carolina on those? No, it
For
was.
vehicles?
It was in Missouri
Yeah.
when my mom died. So
No.
yeah, my brothers and our names were on everything,
Right. Yeah,
even though there was a will and a trust. But
sure.
yeah, it just made it. The trust made everything
Easy.
with the property so easy.
Yeah.
Like all of it was so easy. Yeah.
This man just confused me with the automobile. I want to go back to my Mercedes-Benz. I thought you said that if it was an expensive car, it would have to go through probate, but if it was a Subaru, it wasn't a Mercedes-Benz. It's worse, less than $20,000 that I didn't have an issue.
You have to open a small estate. It's called an affidavit for collection. And if it's worth less
But
than...
that's
It's still a probate. It's still a form of probate. But it's, a full probate could take, the court gives us a year. An affidavit for collection, small estate, the court gives us 90 days. And the 90-day window is to give you the authority to transfer the title.
And that word again was a what? Because I have a Subaru and not a Mercedes.
Affidavit for collection.
Affidavit for,
Collection. That's what your child or your heirs would use to transfer the title if it was in your name only when you passed. Yes, ma'am.
I have a 20-year-old van that I'm still driving. It only has 150,000 miles on it, and I am so happy when I have to go to the DMV. My taxes are so low,
Right.
everything, and my insurance is so low. So I have no desire to own an expensive car.
Sure.
I'm just wondering, a car of a value of, I forgot what the value is, but it's very low, but I'm happy with it. I mean, I've taken very good care of it. So what kind of situation would I be in if I die with that? Should I just be buried in it or what?
So the DMV is getting smarter, and they have a form, I think it's an MVR 17, don't quote me on that. So if it's worth less than $10,000, there's a form you can do. You still have to go to the clerk of court, but it's a much simpler process for a vehicle that's absolutely invaluable, but the value, the net worth of it's not a whole lot. So they've taken better care of people in that situation. Yes, sir.
Can you give us an idea if we have a will or a trust, how much it generally costs to establish a Ladybird deed in your house?
In Wake County, it's $486. So the deed itself is $450, and the recording fee is in Wake County $36. Franklin County is $38. So
So that would be the total price
for the Ladybird deed, yes, ma'am.
for you to do it?
Correct. And record it.
Does it vary among other attorneys? Do you
I couldn't tell you.
Likely, yes.
did you bring us any cards?
Yes, ma'am. I did. Yes.
Other questions?
Is this registered with North Carolina when you do the Ladybird
Is it what?
registered?
Registered? It's registered with the county in which the property is situated. So Wake County, yes, it would be Wake County Register of Deeds. If it's Forsyth County, it'd be Forsyth County Register of Deeds, Franklin County, whatever. But yeah, it's recorded in the county in which the property resides.
How do the liens work on the property? If a lien exists on the property?
It doesn't change anything, so,
It's a title or whatever it is.
yeah. It-
Just has to be satisfied before.
When
it's-
it's sold.
Yeah.
Right. Yeah.
Barbara, do you have?
Just out of curiosity, like when you go to real estate records and you see, the name on the deed or whatever, can't remember how to have it, but anyway, is there any indication there that it's a Ladybird deed?
The very top of it, instead of general warranty deed, it says North Carolina Enhanced Life Estate Deed.
Okay.
So it does. And once in a blue moon, because I do these a lot, every year when the tax administration sends out their bills, 3 or 4 of my clients say, hey, they put my bill in the name of my children. And I'll have to call them and say, hey, you got a newbie over there, they wouldn't know what this is, and they'll fix it. But yeah, it stays in your name until you pass, but it does indicate on the very top of it, as well as in the body of it, that it is an enhanced life estate deed. Yes, ma'am.
This is for Karina.
Oh, yeah.
Quick question. Have you ever sold a house with a life estate deed on it in North Carolina? Did you ever run into any trouble?
Not that I'm aware of, but I'm not sure, because the title work is done
'Cause you
behind
don't
the
see it.
scenes. I don't see it. The title company does that.
Yeah.
So, and the closing attorney. So I work on the real estate side, and, by design, I'm not a licensed attorney, so I don't,
You never saw a hiccup through a closing with,
have not, but,
you don't know if it was there or not?
right.
I got you.
Yeah, and honestly, I look at information on the county website for real estate all the time, and I don't even know that I've ever bothered to look to see whether
that.
it's a general warranty deed or not. I mean, it's there, but
Right.
that's not what I'm looking for when I'm in there. I'm looking for square footage, I'm looking for photos, I'm looking for, I'll look to see if there's a septic permit. I mean, that's what I'm looking for, you know, when I'm doing my side of the work. Yeah, there was,
So
yeah.
that's gonna just be public knowledge, whoever you deed it to, that's gonna be public knowledge that anybody can find out before you die, and then they're gonna be hateful to you, they are not participating in what you've done,
Why would they be disappointed?
because I've left it to someone else.
Oh, because it's visible. So if you had a trust, would it take care of that?
So one of the differences, do we have time?
Yeah, go ahead.
Okay.
Yeah, we're good.
A will is a public document. When we pass, our personal representative will file an application with the clerk of court. They'll attach the will and death certificate. It's put in a manila folder, put in this room with about 300,000 others. But if I go in there and say, hey, and I can actually walk in there, but if I go and say, I want to see John Doe's will, they'll pull it out and I can look at it. Anyone can do that with any will that's been filed with the clerk of court. A trust is not. A trust is a private document. So it will not be filed. So what you could do is the Ladybird deed to the trust. So all it says is that the grantee is the trust. So when you pass away, the property goes into the trust. And then the trust, no one sees that other than your successor trustee, who's like your personal representative, and the beneficiaries. So
Famous
those are the
people
only
set up
people.
trusts so that you can't find out where they
So
live.
they're private. They're
Yeah,
private.
That's
That's right.
like if you were to look up, what's his name that was on American Idol that lived in Garner?
Oh,
Scotty
Scotty
McCreery.
McCreery.
Yeah, he's in a trust, I'm sure. Yeah. Yes.
yes,
Yeah. Yeah, but that's
gotten better
it
over
just shows
time.
the trust. It just shows the trust.
yes,
Mm-hmm.
that's right. So that's a way to solve that problem. Yes, ma'am.
One question leads to another question. It's
Sure.
So one of my children lives in Georgia.
Mhm.
So does this get complicated?
No.
Because they're in another state? So they just take care of everything in North Carolina, and then the money's
So-
in their pocket or whatever, and then they...
Distribute it, yes, ma'am. And one other aside, if you own property in more than one state, not only do you have to open a probate estate here, but you have to open another one in the state where the other property is. So,
My mom did, and she had a trust in both states where she owned property, and it was seamless.
yeah.
So
You
it wasn't a big
You
deal.
avoid all of that with a
Yeah.
trust.
She had thought she'd set up the property in Florida as transfer on death, but Florida's version of that wasn't the same as in Missouri. This was before she wrote a will, because I was after her to write a will. And when she finally wrote the will and had the trust set up, we found that there was an error. It would have actually gone back to when she bought that house. And I ended up inheriting that. My brother got something in Missouri separate. And I would have had to pay, if I'd sold it, capital gains going back to when she bought it rather than to when she passed. So literally the month she passed, because I kept the house and I have it rented, I had an appraisal done. So now if I sold it tomorrow, I would only pay capital gains going back to 2022
When she
versus
passed.
2014, which is
Right.
a huge difference. Yeah, huge.
This question has nothing to do with Ladybirds, but it's a question I've always had, and I've got a captive lawyer audience here. If I hire you to do a trust or will or Ladybird or whatever with me, and I say, I want you to be the executor, your office to be the
Mhm.
executor, and I survive you,
Mhm.
your office closes and you don't have a partner, what happens? Just
We-
out of curiosity.
No, we all have successors. So I have a much younger attorney who, if something happened to me, would take over my practice, notify all my clients, and do that. And if and when I retire, same thing. My successor will take over and notify all my clients that, they've taken over my practice. So we all have that.
If that's a law, that's required, okay,
State bar, yes, sir.
thank you for that.
You're welcome. Yeah. No, it's a good question.
I
It's a
wouldn't
good
have thought of
question.
that, but yeah,
Yeah.
it totally makes sense.
Yeah.
Yeah. Anybody else? Other questions? Okay, you ran out. Wow. Thank you so much, Michael.
My
Let's give him
pleasure.
a big round of
Thank
applause.
you, everyone. I appreciate your time.
I'm going to switch over to just some last slides here. And while I do that, Michael's got some cards. If you all want cards, he'll have those when we finish up. So I just want to show you, this is new on my website. If you're wondering what's going on the calendar, we now have an interactive calendar of events on Southern Accent Homes. So you can actually click each thing and learn about it. So if I had somebody who showed up one day and said, what's that for Coffee Cafe, which is just I'm sponsoring breakfast, right? And they thought it was a presentation. So if you want to learn more and make sure of what you're attending, that's available. And there's a QR code for that. Next month, we've got Lifelong Learning. This is Ollie, which is a program through Duke. So we'll have someone come speak. I can't remember her name offhand. I should, but I don't. And I've already got the back end of the year scheduled. So we'll have new postcards next month with all of the schedule through December. Did anyone here today bring a friend who has never attended a seminar before? You're the friend. Okay. And, well, I don't need to do a ticket if anyone else did. Anyone else? Okay. So we have a winner of the, by default, which happens, but that's okay. So it's actually $100 in Lowe's gift cards. There you go. Okay, I think I've got that up front. Where did I put my... We've got cards right here for Michael, yep. Downsizers Club, you've got the flyer in front of you. The next meeting is next Wednesday. If this is something that you'd like to explore and you haven't been before, I'd encourage you to come. We have a robust group with a lot of discussion about all the stuff that's in our houses. So if that's something you'd like to work on, decluttering, downsizing, that's a monthly meeting, and it'll be back here at 10 o'clock in this room. I have been down that road, which is why we have this class. It was an arduous road, I'll just say. My mother was really good at keeping things and not good at disposing of them. We are now doing monthly tours, many of you know, to different senior communities. The June tour will be on June 11th at Walton Wood Lake Boone. That community is the first one of this, since we've been touring, that will have more than one level of care. So they have independent level, assisted living, and memory care. It is not a CCRC, but it does have 3 levels of care. So the tour is 11:30 to 1. We'll be carpooling from here. You can RSVP. I think Michelle said the email goes out on Monday. So if you want to RSVP for the tour, please let us know that you'll be attending and whether you'll carpool or not. We have a max in my car of up to 7, and we meet from here and go together and come back. If you're meeting to carpool, 10:40 here at the senior center. And we're working on, July is scheduled. I don't remember who it is now. But you'll see it in the newsletter, the cover letter for the newsletter each month. And then we've got a couple of others, but we still have some holes that we're filling for the rest of the year. So we're working on the schedule for the remainder of 2026. Yeah, she told me who it is, and I don't remember. Glen Eyre is July. So we'll have a CCRC in July, and that is the 14th. Templeton, yeah, it's in August, but she had to nail down the day. So we're still working on that. So, and Templeton CCRC. Coffee Cafe, so this date, Wednesday the 27th, which is 2 weeks from today, is actually the day that there's a special event here at the Senior Center. So there's all kinds of vendors that will be here and so forth. It happened that I'd already signed up for Coffee Cafe that day, so I'm going to stay longer. So I'll kind of go from breakfast to dessert, and they have a lunch available you can get here. So I'll be in the front middle lobby there where I always am for Coffee Cafe, just longer than usual. And then I'm also back on June 3rd. So replays are available of our most of our seminars, if they're all recorded. Sometimes we have a speaker who does not want to be recorded, but thank you to Michael. He allowed us to be recorded today. So those are available at Southern Accent Homes. And if you would, pull out your phone. I always forget this, and my team is after me. We need more likes and followers and all of that. So this QR code will take you to my Facebook page. If you wouldn't mind going there, it should take you right in, and you can like us at the top or follow, whichever one it is.
So it's the same thing that's on the card?
No, this is a specific one that takes you right to my Facebook. We have several different QR codes. The one that's on the card takes you to my website, but this one goes to my Facebook page. Can you guys, is it popping up? Yeah, okay. If you'd do that, I'd appreciate it. And just a couple of other housekeeping things. There is a feedback form, so if you would, let me know what you think of today's seminar, and if you have any ideas for future seminars, please fill that out. If you would like to receive a monthly copy, it's free, of the newsletter like this, and you're not currently subscribed, I'll need your information, whether it's if you want an email version or a snail mail, it doesn't matter to me. I'm happy to include you in the mailing. If you would like the new directory, there's a few copies over here. This is everything senior living in the triangle, from 55 plus communities, independent living, CCRCs. There's a link for subsidized housing. It's literally comprehensive. So if you would like a copy of that, there's over here on the table. I think I covered it all. Okay. Any last questions or comments? Thank you all so much for coming, for your participation. Really appreciate it. Look forward to seeing you at next month's seminar and hopefully at the Downsizers Club, the tours. We've got a lot going on. So have a great month.